Hello, my name is Randall Borden, and welcome to my podcast. Today's guest is John McKenzie. He's a seasoned trial lawyer with a background in business, malpractice, and government disputes. He's worked on both sides, the plaintiff and the defendant, and in areas of trademark, copyright, privacy. His experience, a former chief financial officer, graduated from Indiana University School of Law, also Wharton School of Business. He's worked in large law firms. He worked in state government, litigation boutiques, and he's here to give us insights into his experience and hopefully get us get us rolling on how we can improve ourselves. So welcome aboard. And could you tell me what what your law firm is today and how big it is and how it works and such?
Sure thing. Thank you for having me today, Randall. So
Sure.
our law firm is Holmes, Costin, Marcus, PLLC.
Mhm.
Holmes, Costin, and Marcus is a small law firm. We have four lawyers. I am the fourth lawyer, the most recent addition. I joined in January of 2024, so I just celebrated my 1 year anniversary.
All
And
right.
our practice is really focused on the DMV area, but in particular, Virginia. We have a lot of cases in Virginia. I've had some cases in Maryland, but for the most part, it's federal court and state court in Virginia.
Oh, okay.
Two of my partners clerked on the EDVA for Judge Brinkema. And
Mm.
so we have a lot of experience with federal court. I just joined the EDVA bar last week.
Okay.
That was kind of a fun experience in Alexandria. Got to learn all about the rocket docket. That was
Right.
fun. And then our practice is mostly commercial litigation. And we represent both plaintiffs, but both individuals and businesses. Most of the cases I would say are in the $500,000 to $10 million range in terms of amount in controversy. But before I joined, I can't claim credit for it, but before I joined, my firm was actually co-counsel on the largest verdict in Virginia state court history. It was a case of Appian v. Pegasystems, and it was a $2 billion verdict. It just got reversed on appeal, but there's now a petition pending for Supreme Court review, so we'll see what happens. But yeah, it's I really feel fortunate to join them. I'm very happy to be here. I just moved to Virginia, Maryland area 3 years ago.
No, okay. Where'd you move from?
Dallas, Texas.
Oh, wow. Okay. What brought you up here?
So my wife's family is from Kensington, Maryland.
Okay.
So we
All right.
decided to come up here and be closer to her family, and we were gonna try it out temporarily and see if we liked it, but we like it. So, and I
Mhm.
worked remotely for my prior law firm, which at the time was named Deary Ray, but now it's Silvera Deary Ray, and they're a great firm. They're a wonderful firm. Their practice is the plaintiff side mostly, but they do defense work too, and they are focused on tax controversies, not the actual controversy with the IRS, but suing your tax advisors for bad tax advice.
Ah, okay. That kind of tax controversy.
Yes, exactly. Exactly.
Whoopsie. Okay.
Yes, exactly.
Right. Now, do you do jury trials? Do you do mostly judge trials or bench trials or what?
Most of my experience has been bench trials, but our
Hmm.
firm does everything. They
Oh,
do
mhm.
jury trials, bench trials, arbitrations. I'm involved in three arbitrations right now. But, as you know, the vast majority of cases resolve before trial.
Right,
So
right.
the Appian case, the Appian v. Pegasystem case, that went to trial. It was a very long trial. I believe it was 6 weeks. And they
Hmm.
had a 2 week separate trial on just the statute of limitations affirmative defense.
Wow.
So the defendant raised that as an issue. It got decided resolved against them. Then they had the trial on the merits, which was also resolved against them. But it was all jury trials.
Hmm.
So we do both, but a lot of controversies these days go to arbitration, especially commercial ones, because there's usually some sort of contract that has an arbitration clause in it.
Mandatory arbitration clause, right?
Yeah.
Do you do, who pays your bills? Is it the insurance companies or?
Clients pay our bills for the
Okay.
most part. Like our client, we get directly paid by the client. We have a retainer. We
Mhm.
don't do contingency work. We've never done contingency work
All right.
at this firm. At my old firm, we did do contingency work, but a lot of times we're representing individuals where insurance is not going to be available. So we're
Oh,
not doing a lot of, we're doing like, business divorces. We're doing like personal disputes. Like sometimes we're doing trust disputes and stuff like that. And so there's no like directors and officers insurance in a lot of these cases, but it's our clients usually, we try to position ourselves as kind of sophisticated for our price. Like we don't charge like obviously big firm rates, like huge firm rates, but all of our lawyers have worked, or most of them have worked for larger firms in the past. So Dick DeGuerin, famous Texas trial lawyer, used to have a saying. He used to say, "My fees are a bargain at any price." But we don't go that far. But we try to be like, a more affordable option, I guess you could say. That's litigation is just expensive, right? I mean, a
Mhm.
commercial dispute is usually hundreds of thousands of dollars if you're going to go all the way to trial. So
Right, right. And then do you have where's your office located?
Alexandria, right off
Oh,
of King Street. So
okay.
we are, if you're familiar with Alexandria, we're right. So you have the waterfront, and then the
Right.
next like major arterial road is Washington Street.
Hmm.
And so heading away from the waterfront. And so we're right past Washington Street, a couple blocks away.
I used to do like 2 decades of bankruptcy work, so I was at the bankruptcy court down there all the time. So,
Oh, nice.
yep.
Yeah. Bankruptcy is a fascinating practice. I mean, I just think like it's so cool and it's so technical. Like you really have to know what you're doing if
Right,
you're in
right.
bankruptcy.
Well, and also it gives you worldwide jurisdiction. So you
Yeah.
can, sue or stop a creditor here or get collect a debt over there, gather information. They also have a Rule 2004 exam, which allows you to just fishing expedition. Give us your file, let us
Hmm.
let us see what's inside of it, and then we'll decide what to do with it. So yeah, I did more the low level individual chapter sevens, a few chapter 13s, a couple of chapter 11s, but a lot of work and you don't get paid. People don't have money in bankruptcy, so that's
Well, that's the problem, right? Unless you're like
right.
a huge corporation with a massive Chapter 11 type case, like
Right.
your clients are struggling, right? They're
Mhm.
trying to
Mhm.
get out of their debts.
Well, even the big
And they're,
ones, they have to take a haircut. They may have $200,000 in the escrow when they file, and now they got a bill for $1 million and they can't
Mhm.
collect it. They need bankruptcy court approval. So it can get sticky, but
I like to read the fee applications in the bankruptcy court from these really large law firms, right? Because it'll be
yep.
like, it'll be like first year associate, 950 per hour. And you're like, okay, they're probably anticipating that some of this isn't going to get approved, right? Like there's going to be a haircut of
That's
some
right.
type or another.
Well, if the creditors don't object, a lot of time it just goes through. So there was
That's amazing.
there was one big case I heard they charged 100 hours for
Hmm.
redoing the bill. And the judge says, "What is this?" And he said,
Yeah.
"Well, Your Honor, we had to take the bill from our old format and redo it into the bankruptcy court's format." And the judge approved. Okay, judge approved it. No creditors objected. So there you go. But
That's amazing. I
mm,
guess that by that point in time, they've worked out a deal for what the creditors are going to get. So they don't, it's not worth any one creditor to fight it.
or not get. Well, most of the
Yeah,
creditors just gave up and will be happy to get a check for $42 in 2 years. Begin. Yeah.
absolutely.
Right.
Absolutely.
Right. So how do you see the legal market in this area? Is it still booming? Is it going up, going down?
In this area, I think that, I'm comparing it to Texas
Hmm.
and I'm comparing it to the Texas market's really exploding with a lot of new entrants into the market.
Right.
But I think litigation, which is what I do, is is not really growing that much in Texas. But I think the market here is really rich and diverse because you have so many jurisdictions intersecting in one place. You
Hmm.
have obviously Virginia state jurisdiction, Maryland state jurisdiction, DC Superior Court jurisdiction, and then you have all the federal courts that are here. And there's a lot of interesting federal courts, not just District of Columbia, like the Eastern District of Virginia is very interesting, District of Maryland, interesting stuff. So I think the market here is great. Now, whether it's growing or not, I don't know. I mean, it's interesting because now, of course, we've had like a change in administration, so there's going to be a lot of federal. It looks like a lot of federal employment disputes, a lot
Right.
of admin law disputes, which is admin law is kind of a discrete area of practice,
Right.
and a little bit esoteric. And now it's like coming to the forefront as to what are
Hmm.
the legal requirements of agencies and stuff. So I anticipate there being a lot of litigation over that in the next few years
Right.
and kind of settling what are the parameters and what are the limits and legal requirements for and how much discretion the executive has in terms of reforming the executive branch to their wishes. I think that's all going to be hotly litigated. So I think like certain practice areas will certainly explode in the next few years, but I think it's kind of like steady state, I would say here, because, in Texas, they were really big on tort reform, right? I mean, tort reform was a big deal and they
Oh,
tried to, I see a lot less of that here, a lot less of a movement for tort reform.
mhm.
So it seems like it's going to be pretty much the same. Tort reform did change medical malpractice practice in Texas quite significantly when it
Mm.
passed. But I think that there's a damage. I know in Virginia there's a damages like a hard cap of damages for medical malpractice.
All right.
But in Texas, I want to say that your actuals are not capped. So if you have like a horrific accident and you need, like lifelong nursing care and stuff like that,
Right.
you can get it. It's not a hard cap. You can get it. But your non-economic damages are capped at, I think, $500,000 for a hospital and $250,000 for a physician.
Mm.
So if you have like, you know, a sort of bad outcome, but you don't need lifelong nursing care or whatever, you're not going
Mm.
to probably get a lot of a recovery in Texas.
Right. Right. That's the fair reputation of Fairfax County is
Mhm.
you'll get compensated, but you're not getting rich. The juries are real stingy. This is my insurance money from my
Yeah.
car insurance. So,
No, I mean, and that's why the community gets to weigh in. The
mhm.
community gets to have its sensibilities reflected in the verdicts.
Right.
So as part of the deal, which is part of why, I mean, I kind of think like each verdict is going to reflect the community's values, which is how it's supposed to work, right? So
Correct.
tort
Mhm.
reform kind of supplants the jury's judgment with the legislator's judgment as to what the case ought to be worth. And and as you said with Fairfax County, juries are not oftentimes eager to give out huge sums of money for cases they don't think warranted, you
Right.
know?
Right. And don't forget to include in the DMV area now, include West Virginia, the Panhandle, parts of Pennsylvania, Gettysburg, and even Delaware.
Mm-hmm.
So that's kind of expanding, and you see a lot of people, operating in both places. They live
Mm-hmm.
there, they work here, live there for affordable housing, and work here. So.
Yeah.
Yep, yep. Well,
Mm-hmm.
so as far as what the future of law would be, what do you think? I mean, is it going to be entirely remote? Are they going to go with computerized judges like
What do I think?
Elon Musk?
I don't think it's gonna, it's funny. I think AI is obviously going to alter the practice of law in some way or another. I know that AI regularly hallucinates
Mhm.
cases. And I asked ChatGPT, why do you hallucinate cases? And it didn't give me a really responsive response. And I said, it seems to me, I said, I told it your answer doesn't really respond to my question. I was like, I'll tell you what it looks like to me. It looks like to me that you, ChatGPT, are trained to give output of natural language. So
Mhm.
you create syntax based on being trained on natural language, and then you output natural language.
Mhm.
I said, but citations do not conform to natural language. So what you do with a citation is you create a citation that looks like a legitimate one. And in other words, it has all the components of a normal
Right,
citation, the
right,
case name, the volume number, all that stuff. But you don't do any quality control on the back end to make sure that that case actually exists.
right,
And there's
right.
and it said that is correct.
And after
So
that, it never worked again.
so I know that there are some AI products that that do have some sort of mechanism for checking to make sure that the case is
Mhm.
legitimate. I know I've heard, though I don't know for a fact, that case text, for instance, they have an LLM model that they have applied to a purely legal database. So all the materials that the model mines from are actual legal authority.
Real, yeah. Mhm.
Yeah. And so I think that those products are going to probably hasten, the creation of memos on
Mhm.
the early part. But I also think that unless parties, you know, consent, I've seen products that are being emerged like a virtual arbitrator,
Mhm.
where you basically can go and submit your controversy to a virtual arbitrator and they'll render a decision really fast, one way or
Right.
the other. But unless people consent to that, I don't I don't see people outsourcing the actual decision to a robot. And
Hmm.
I don't, obviously, arguing in court is something that's going to have to be done by a human. I don't think that they're going to allow robots to argue in court. And witnesses obviously are going to have a human element. And juries, see, that's the thing. It's like the law has baked in, basically because of constitutional requirements, certain human involvement, right? Like juries are going to be there,
Right.
and the actual
The whole
party,
confrontation clause.
yeah, the adversarial component of it. So humans are an indispensable element to at least some parts of litigation. And it's kind of like pilots. They've had the ability to fly planes remotely for a long time, but we still have pilots.
Right.
I just think that the way we're wired emotionally, it's going to be hard for people to completely trust a totally automated justice system. I think that they want to have a human at least doing quality control on the back end to make
Right.
sure that the robot is not going crazy and
Hmm.
making silly decisions. So I think that there will be efficiencies. I don't think that the practice of law is going to completely change, especially
Hmm.
litigation. I do think that you'll probably be able to get AI to make pretty sophisticated forms. So you can probably get them to make, in transactional work, and also when you're trying to negotiate settlements, when you're
Right.
trying to negotiate custody for family law, doing wills and stuff. I think a lot of that on the front end will be done
Hmm.
by robots. But again, there's always going to be a quality control component to it. And I look at how big law kind of evolved. I started off in big law. I have a lot of friends who work in big law, and those firms, they really grew in headcount right when you had this digital revolution where we as a country transitioned from a manufacturing economy
Hmm.
where each worker creates very little data every day to a digital economy where each one of us goes into a desk every day and just pumps out data for 8 hours a day
Right.
in Word
Right.
documents and Excel and email. We leave like a digital breadcrumbs all day, every day,
Yep.
8 hours a day. And for a long time, you had to have human eyeballs collect and review all of those breadcrumbs, which of course
Hmm.
created a huge need for lawyers and
Right.
big law firms to review all that data. But you're going to have I think it's a problem that technology created, and it's going to be a problem that technology ultimately solves. And I think you're
Hmm.
going to see in discovery, it's going to be 80% machines, 20% humans when it comes to the review process. You're
Right.
going to have a machine trained by a human to review a batch of documents,
Hmm.
and then it's going to take that training and apply it writ large to the whole production. And then on the back end, a human's going to do quality control to make sure that the machine is actually tagging the documents
Right.
like they're supposed to be tagged.
Hmm.
And I think that actually will happen. But I don't think that's a bad thing, because
Hmm.
all the problems that the digital economy created in terms of data review, those should be solved by
Yeah.
technology, in my
Hmm.
opinion. Like it's it's not a very fulfilling, rewarding legal career, in my opinion, to just do review and nothing else for a very long time.
As
That's
first year associates, that's what I did. Here's
right.
here's a room, 50 banker boxes.
Right. Exactly. And back in the day, I just missed it because I graduated in '08. But I heard
Hmm.
from lawyers who were like the generation before me, like 5 or 6 years ahead of me. They did the banker's boxes. They had hard copy documents. They didn't have
Hmm.
these digital review tools that we now use kind of
Yeah.
routinely.
Yeah.
And yeah, that's what first year associates did. They'd go into a war room, they'd go into a document room, and they would go through bankers boxes and sort them into, and tag them in piles.
But no, we tag them, and then they go off to the copy department.
Hmm.
They take them all out, copy them, put them back in, staple them. Then you got your stuff for your trial. You got the original documents. Yeah.
Yeah, it was all a manual process, right? There was no
Hmm.
other option. So I do think depositions will be done. I mean, you're already seeing it. A lot of people do depositions remotely now.
All right.
I like to do it in person.
Yeah.
I think that the travel piece of a deposition is kind of the least expensive part for the most part, right? I mean, the hourly
Mhm.
rate, usually 1 hour of the hourly rate will approximates a lot of the travel costs, so you ought to just, if you can, get there in person. But I know for a lot of people who have cases nationwide or even globally, I was talking
Right.
to a friend yesterday who is an expert witness in construction cases, and he was saying that before Zoom, he doesn't do it anymore, but before Zoom, he would get notice like, "Oh, you need to be in Dubai on like Wednesday,"
Yeah.
and it's Monday, and he's like, "What? Okay." And so that kind of stuff, I think, is going to go away because why would?
Mhm.
But the actual and even the depositions, but I there's some things I think in person, you pick up visual cues in person that you just don't get 100% digitally.
Right, right. And also, you don't know if somebody's sitting here or here, feed them the answer, or here, feeding them the answers. Could you stand
Yeah.
up and swing around the room, please?
Yeah. I mean, a long time ago when I was working at the Texas Attorney General's office, I was deposing a congressperson
Mm,
because that congressperson was a party in the case.
mm.
And that congressperson's lawyer was openly whispering answers
Yep,
to the
yep.
congressperson. And I was a very young lawyer. I was like a second year lawyer or something.
Mm,
But I couldn't believe it. I mean, ultimately, like I didn't make anything of it. I was just trying to sort of understand the limits of the witness's knowledge, what they were
mm.
going to actually testify about,
Right.
which wasn't very much, as you can imagine in a lot of political cases, the named parties don't know a whole lot about the case. They're kind of almost like a class representative in a
Right.
class action. There's some bigger issue in dispute, and they're just there as a named plaintiff. So he
They
didn't
know a lot about their case, but not about the rest of it.
the whole issue, right?
Right.
And their case is like a small piece of a bigger
Mm.
picture. So, but it was a lot of fun. But it was funny because that guy was just openly whispering answers to his witness,
Yeah.
and
Mm.
if I was a little bit older, I might have just asked on the record, did your lawyer just whisper to you?
What did he tell you? Please repeat it.
Right.
Well, they know they have a new service I saw, Deposedly, something
Hmm.
like that. And again, they advertise they can do depositions anywhere, give you a certified transcript, and not quite sure how you get it into court if it's not Virginia's, but I imagine you could use it as a request for admission, that admit that this is everything you said in the deposition. If not, please make the corrections or something.
Yeah.
But anyway, that's a service that is out there. I haven't used them, but they're advertising quite a lot. My problem is I'm in family law, and my clients just can't afford depositions. I mean, it'd be fantastic, if we could, or like right before trial, we could call them in and go through all the documents. But they most of the time they just don't have that luxury to do that. So yeah, so it is what it is. We got the clients we got. So
No, I mean, I think that's like, it's good if you can resolve things without depositions, right? I
right,
mean, like, from a lawyer's perspective, I always like to have as much information as I can because obviously you have the duty of diligence as
right,
one of your ethical duties. So I construe that to mean like try to get your hands on everything you can get your hands on and all the testimony you can get. However, as you say, it's expensive to do a deposition. If you're paying lawyers $300 to $500 an hour to sit
right,
in a deposition and it's going on for 6 or 8 hours and the other side has their lawyers and you have a court reporter, it gets to be multiple thousands of dollars very
right.
quickly.
Hmm.
And that's just for one. So I also think that, I don't know, and I hope, and I haven't practiced family law, but I did used to witness it sometimes because I was a clerk in law school. I was a clerk for a Texas judge.
No,
And in Texas, in certain counties, the judges don't have subject matter limitations on their jurisdiction. So, like in a big county like Dallas, you're going to have the family law court and you're going to have
mhm.
the civil court and you're going to have the criminal court. But in the more suburban and ex-urban and rural counties, the same judge is going to hear all those types of
All
disputes.
right.
So
Hmm.
I was working for a judge who was in a suburban Dallas county called Collin County, and they heard everything. And I would watch these family law hearings. And I remember there was one where the client was represented by an attorney and the husband was self-representing. The wife was represented by an attorney. And it came out during the hearing that the wife had run up credit card bills of over $100,000 on her attorney. doing her family law work. And
Yeah.
the husband was saying, look, I'm representing myself because I don't want to accumulate $100,000 in debt
Yeah.
to do this. And so it's, a lot of clients, a lot of disputes are ordinary people, and spending thousands of dollars on a dispute is something that's the material impact to their
Yeah.
standard of living, their quality of life, their
Their,
financial health,
their
everything else.
children, you know.
Yeah. And
Yeah.
that's really what it's all about in family
Mhm.
law. If there are children involved, you really want best interest of the child. That's the legal standard.
All right.
So, that includes where you can saving money during. So I think that
Mhm.
the obvious caveat to the diligence requirement is within the abilities of your client. Like if your client
Yeah.
can't afford it, you also have a duty to not have unreasonable fees. So you do your best to balance those competing interests.
Right. Right. But all right, so we're getting near the end. Do you want to tell a story about your most interesting client or craziest case or?
Yeah, I love these kind of war stories because they're like whenever I go to bar events and I ask an older attorney this type of question, you get such great great stories,
You're
right?
not going to believe this.
Yeah, but I have to say that the kind of probably the most interesting cases that I had were working for the state of Texas in the state attorney general's office. I was working on a lot of Voting Rights Act cases, and those cases were obviously political, right? So there's that piece of it, which I'm not used to in most cases, right? I was coming out of working at a big law firm. There was just purely commercial issues. So there's a public relations piece of the case that I didn't handle at all. It had nothing to do with me.
Right.
But it's like your case is being reported in the press,
Mhm.
and people are coming to your members of the press are coming to your hearings and taking notes and
Right.
publishing
Right.
stories. But in that case, Texas was
Sit
being
up
sued.
straight and
Yeah, 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 absolutely. But Texas was being sued for its legislative maps, right? Because the legislature has to
yeah.
draw a state house map, a state senate map, and a state board of education map, and also a map for congressional delegations, right? So
Mhm.
they have all these maps that they're drawing. Those maps get challenged in court, and there is an actual like practical issue with those maps, which is the legislature or the Texas Secretary of State has to know where the lines are going to be so that it can print out ballots, right? Because what
Oh,
names appear on the ballot correspond to what House district you're in and
all right.
what state Senate district you're in. So if those lines are going to change at the margins, they're not going to have the right ballots for every precinct
Mhm.
unless that question is settled.
Right.
And that question needs to be settled several months ahead of the primary. And the
Mhm.
primary is several months ahead of the general
Yeah.
election. So you start backing your way out of these deadlines, and like you realize you only have a few months for the court to make a final decision.
Oh.
And so those cases get filed and get all the way to trial in the course of like 5 months or
Oh.
6 months. And it is just crazy. The schedule is brutal. I was
Mhm.
pulling like an all-nighter once a week for the month before trial because I just couldn't get everything done. And
No.
it's a good thing I was like 28. I can do
Exactly.
that. I don't think I can keep that pace anymore. But
All
it
right.
was it was just totally crazy. And because of the unique interests involved, you get like a very interesting cast of characters in those cases because
Mhm.
you get people who are lifers in the sort of public interest law space, and they
All
do
right. Right.
advocacy work, and they represent, like LACP or LULAC, which is a Latin American or Hispanic American advocacy group.
All right.
And you have a bunch of other groups that are have a common interest with those groups, and the lawyers, it's just a totally different practice.
Mhm.
And the witnesses also, like the named plaintiffs, like they all have different backgrounds. A lot of them are also have an activist sort of
Mhm.
background, and the judges have a unique interest in these cases because it was my experience that they were very solicitous of the arguments of the activist side, and they
Mhm.
were very protective of the right to vote, which I think is great. Like you want the courts to be protective of the
Right.
right to vote. And but it was just totally different than my commercial practice where, for the most part, you got the feeling that the judges didn't really have a dog in the fight. And
Right.
on the other
Mhm.
side, it's all about money. A great mentor of mine named Jim Flegel, who sadly passed away, but he used to say, there's three types of cases. You got cases that are all about the money. Those always settle or usually
Mhm.
settle.
Right.
You got cases that are all about principle and those never settle. And you've got cases in between where it's some about money and some about principle. That's where most cases fall.
Right.
And they will oftentimes settle, but not always. But in the case of the voting rights and the voting rights cases, it's all about principle, right? It has
Right.
nothing to do with money. Now, the law firms under the statute, under the Voting Rights Act statute, if the law firms prevail, they can collect their fees. Okay.
Right.
But money was not the issue in those cases. The cases were about, really kind of fun, fundamental questions. What
Mhm.
are the powers of state government? What are the powers and rights of the individual? What do you do when those two collide?
Right.
And it asks a lot of sort of deeper questions about like, you know, how we should structure our democracy and how we should protect people from having their voting rights degraded in some way or
Right.
another. And they were really, really, really fun and really funny characters. And you had a mix of people that was really kind of the most fascinating group of people that I'd ever litigated with.
Mhm.
And it was also great because everyone was really passionate about their position, but also super respectful and kind to the other side,
No.
which I really
Yeah.
appreciated because people can get really passionate about these kind of fundamental questions. And everyone was like very, very friendly on a personal level. But yeah, I remember there was one guy, this is a funny story. It was my first ever deposition. And there was a guy in there who was defending the deposition. And I suspected that he wasn't a practicing attorney anymore.
Yeah.
And so I looked him up afterwards, and it turns out he wasn't, he literally wasn't a practicing attorney. This guy was appearing in a deposition in Texas. He used to be barred out of state, but he didn't practice anymore. He
Uh,
had changed into becoming an expert witness most of
right.
the time. And so he testified on certain subjects, but for some reason he was chiming in during this deposition. And I remember that the lawyers on the other side, like we went into court and we informed the court, we're like, I don't think this guy's a lawyer anymore. Like I went to the bar where he used to be a bar. I looked up his name. His name doesn't appear in the records of the bar anymore. And so I don't think that this person's a lawyer anymore. And one of the lawyers on the other side was that some young lawyer is doing some research on this guy, but he's not gonna. Don't worry, Your Honor, he's not gonna appear anymore. He's not gonna do anything. And I was laughing. But the thing is, like, I don't know. Obviously, I didn't want this guy to like be prosecuted for
Right.
practicing without a license. I wasn't like I didn't wish him any ill will or whatever. I just
Mhm.
didn't want him defending any more depositions. So that
Right.
was that was good enough for me.
Yeah.
But yeah, that always shocks me, right? Because I read the rules of ethics and professional conduct, and I'm like legitimately scared of violating them. I don't ever want to. I don't even want to come close to it, right? I want to stay many
Right.
miles away from violating those rules.
Yeah.
And when you practice long enough, you see some lawyers on the other side who are really cavalier about it. And you're
Mhm.
like, I'm it's it's really strange to me like to see that because I think like okay, like come on, this is like everything. Your law license is your whole career, right?
Yeah.
So you've got to do your best in good faith to follow all the rules. And the rules are lengthy and some of them are complicated. So, there's certainly edge cases or whatever. But it's just interesting to me to see guys like that guy just practice without a license. I mean, what's he doing?
Right. Right. My fallback on that is always, ask the question of the Virginia bar or the Maryland bar.
Right.
Then you've covered yourself. At least you know what the issues are. If
Hmm.
it's definite or if it's kind of on the one hand, on the other hand, but you've made the effort, you've checked the box, you recognize the issue, and then move ahead accordingly. So that's
Absolutely. I think that, a lot of these things are a lot of the law and a lot of ethics turns on good faith. Are you
mhm,
good faith? If you are reaching out to the bar and saying, I flagged this issue, I need guidance on how to proceed. Can you
right.
provide me any sort of guidance? Then you are absolutely practicing in good faith, right?
Mhm,
So that's like, and if you, especially, of course, you have to heed their counsel, whatever it is. But if you reach out and they give you counsel and you heed it, then I think you have a very good argument, should anything ever come of it, that you were operating in good faith and
right.
trying to do that.
Mhm,
It won't spare you necessarily every violation because not all of them turn on good faith, but in terms of remedies, it will hopefully help you on that at least.
right.
But yeah, it's just funny to see everybody has a different approach. And some people are just really super casual in their practice, and that's just the way they operate. And it's I've seen people who are successful in all different types of ways. So I
Mhm,
hesitate to say like everything has to be super formalistic, but for me, for my practice, I like it better if it's formal, just because it helps set expectations, and hopefully you're not dashing people's expectations because there was a lack of clarity and they filled in the gaps with their own sort of supposition or imagination as to what might happen, and that wasn't actually what
mhm.
happened.
Right, right. Yeah, I call it skipping through a minefield. It's very
Yeah.
unlikely you'll blow up, but
Hmm.
better to go around.
Yeah. No,
So,
absolutely.
mm,
So yeah, I mean, I love the practice of law. I think it's the coolest job. It's not without its stresses or whatever,
mhm.
but it's real life. I'm sure in family law practice, like you are really dealing with real life issues, like really
Yep,
important issues.
yep,
How this
mhm,
family is going to grow up, how these kids are going to grow up, what the
yep.
relationship between the parents are. How can we keep everybody with enough money to survive, enough like security, and make sure that the kids have the best possible chance of success. There's also,
Contact between each of the parents,
hmm
cordial exchanges, each one involved in the children's life going forward, enough money to go around.
hmm
One household to two households. It's not going to work in this area. It's just too expensive. So what's going to happen? What gives? Are you going to move in with your parents? Are you going to rent a room in a basement? And that's a big factor.
yeah, it absolutely is. Like this, compared to Texas, this is a much more expensive place to live.
Yeah.
And so, like it's oftentimes necessary to have two incomes
Hmm.
to have sort of a larger household.
Yeah.
And so and if you're going to split those two incomes up, everyone's going to have to make adjustments to sort of accommodate that reality.
Yeah.
So yeah, I feel like when I talk to people about the law, I tell them, the vast majority of us have very little interaction with the courts, and if we are going to have interaction, it's going to be through like a traffic citation or
Hmm.
family law.
All right.
That's generally speaking, if you have an interaction with the legal system, that's where it is for most of us.
You get called for
Um,
jury trial.
yeah, yeah, jury duty, sure, jury
Right. Right.
duty, but as far as being like a party, you're only going to
Hmm.
be a party usually if you have some sort of traffic issue or if you have family law
Right.
issues.
Yeah.
And family law is to me like that's where the rubber hits the road. That's where people actually, and you really do you do need the lawyers and you do need the courts to help these families out of their predicament, right?
Right.
Because they're stuck in a situation that's not working for one or both parents, and you need help to come up with the resolution that's going to let everyone move on with their lives. So I think like it's kind of like doing a real public service to practice family law because you're solving real problems that need to be solved.
Yeah. I mean, what I tell them is this is probably, we gather the facts in discovery.
Hmm.
And this is probably, you could spend more money on a deposition. You could spend more
Yeah.
money on an expert. I'm not sure it's going to be worth it, or maybe we should or shouldn't. Here's what we got. Here's what we're going to go to trial with. Here's how I
Hmm.
think the judge is going to decide it. You've made accusations. I don't think you can prove this one and this one. We can prove
Hmm.
that one and that one. The other side's made accusations. It's kind of what we got. You want to
Yeah.
spend another $10,000, $20,000 to go from this point to a trial, or should we send over a settlement agreement. And at least send over an agreement. We can argue about the numbers and who gets what, but get it as a, starting point, the boilerplate. That's kind of what I like to do. And then hopefully everybody focuses and, comes to their senses. But some people
Hmm.
don't. I know I want to I can convince the judge. I get that. Okay, well, you're going to pay for it.
Yeah, no, that's true. I mean, it's funny that people have such confidence because I tell people sometimes, not
Are we cutting you off on your
oh, it's
soccer game?
fine.
Oh, okay.
It's her second game. I'll be out in a minute. I'll catch almost all of the game.
No, don't start doing that.
Oh, I never do that. Like I've
Okay.
never missed like even 5 minutes of a game, except
Okay.
unless she tells me, hey, I want you to go out and get donuts
Right.
and come
Yep.
back to this
Yep.
game with my donuts. But yeah, as far as like convincing the judge, in my opinion, I like to tell people you are when you're trying to go to court or whatever, you are trying to convince a third party to agree with you, be it the
Yeah.
judge or the jury, and how it's like, and it's not a hard science, right? It's not like
Mhm.
if you put the same inputs in, you're always going to get the same outputs, right? Like in chemistry, if you put like hydrogen and oxygen together, you're
Uh-huh.
going to get, and you add electric current, you're going to get water, or whatever.
Right.
In law, it doesn't work that way. So
Mhm.
I was like, have you ever been in a situation in your life where you thought the facts favored you and the principles favored you, but yet you couldn't convince the other person that you needed to convince that you were right?
Yeah.
I was like, yes, of course, right? All of us have been in that.
Mhm.
All of us have been in that situation within our own families many times,
Right.
and they love us theoretically. So
Mhm.
like a judge who doesn't love you or a jury who doesn't love you,
Yeah.
convince them. And there's just a lot of uncertainty in that, no matter how compelling subjectively you believe your case is. So
Mhm.
you just have to be aware of that going in, that nobody knows for sure how it's gonna
Yeah.
unfold.
Yeah. Can you talk about a little bit about your, I guess, intellectual property practice at
Oh, I'm just interested in that. I'm
Mhm.
not a big intellectual property lawyer. That's
Oh,
an area of interest. I read about it a lot.
no.
I wrote one brief article about it when there was a decision in the District of Columbia District Court where somebody tried to claim copyright protection over an AI generated product that was
Yeah.
machine authored, and the court declined to find copyright because the parties had stipulated that it was machine authored completely. And the judge, I think, I'll have to reread the opinion, but I believe she said, there might be an open question as to whether or not, the specific way you prompted the
Right.
AI to
Uh-huh.
create the thing, whether that's copyrighted. But the output itself is just not copyrighted. So I wrote a brief article about that for publication. But I don't practice every day in copyright.
Okay.
I don't, or in trademark or whatever. I leave that to the experts. It's an interest of mine, and I also am interested in privacy law, but again, it's just an interest. Most of my practice, 100% of my practice really is commercial litigation.
Yeah, the privacy is interesting because if you start feeding good ideas into AI, doesn't somebody read that? I mean, aren't you kind of disclosing your potential invention or
No, there's very thorny questions about how much confidentiality you preserve when you start feeding things into an AI engine.
Mhm.
Obviously, it's a big issue for the law because of privilege,
Right.
but there's just a general issue with, that AI is not under our control, and there's a question as to what, you'd have to read the terms of service, which I haven't done. But my
Mm.
suspicion is that they reserve the right to train off of the prompts you're giving them and everything else and all the outputs they generate. In which case, like, you're giving them everything,
Hmm.
right? Like
Right.
you have no expectation of confidentiality. And so I've watched on LinkedIn, lawyers opine on how to deal with
Right.
that. And some of them say, kind of strip out all the facts of your case. Don't put any personal facts into the case or whatever. But it's like you're on the borderline of attorney work product or whatever.
Right.
So I don't I don't know. There's going to be I'm sure there will be case law about this. And at some point, there may even be a legislative response that kind of settles the question as to how much confidentiality you're entitled to.
Right.
But you almost need a uniform, if it's going to be at a state level, you need a uniform act
Right.
because you're going to have like California have one standard, Texas have one standard,
Hmm.
Virginia, Maryland. It's going to be impossible for these AI companies to
Yeah. Well,
comply.
DeepSeek, got a lot of publicity on, duplicating
Hmm.
ChatGPT, but another thing they did was let you download the
Hmm.
the software to do it. And you
Hmm.
would need your own computer, bigger than a laptop or anything, but apparently an off-the-shelf computer. And
Hmm.
then you could feed in whatever you wanted to, and it would stay with you. I guess it would go out if you're inventing a new chemical, it would gather chemistry information,
Hmm.
and then you could feed in your ideas, but
Hmm.
you had the physical computer, and everything is physically there with you, and no dispersion out into the web.
Into the cloud. Yeah, that would
Mhm.
be an interesting development. I mean, they're going to be like a lot of products are going to proliferate about this, but I mean, I've tried to just ask, a, is there case law on subject X?
All right.
And they'll say yes, and I'll be like, can you provide me citations? They provide me citations. It's
Mhm.
regularly hallucinates. I mean,
Oh, wow.
more often than not, in my experience,
Mhm.
hallucinates. So I stopped trying to do that because I thought I can get better results from just doing my own searches in Westlaw than relying on. And I used to, when it would hallucinate cases, I used to tell it, you hallucinated this case. And I gave a citation. And it would say, you're absolutely right. I did. And I'm
Well,
just like, I mean,
I do it with, ChatGPT and Westlaw side by side.
yeah,
So, and some things we're experimenting with is like feeding in, 3 years of bank statements. We
yeah,
have to get those all the time in divorces. Tell us what's missing,
yeah.
which month is missing. So far
Hmm.
it's not working, but we're trying, that they evaluate discovery, tell us, what's the income, what's the
Hmm.
largest charge made on credit card, the top 10 charges on a credit card, that kind of thing. So we're trying, but it's not there yet.
Yeah, I mean, I have every confidence that the product's going to improve a ton. So, I mean, like, I don't think it's one of those things where you say, "Oh, I'm never going to use it" or whatever.
Mhm.
But that said, I think it's a long way off. I do. I just think that like it's years away from being a reliable tool for lawyers, which doesn't mean it's useless. It just means that you can't rely on it without really site checking and
Oh yeah.
doing due
Yeah.
diligence to make
Mhm.
sure. And so if you're maybe at some point, you start to realize like, oh, I feed in all this information and it does reliably give me the biggest charge or,
Mhm.
the missing statements or whatever. And then you can have a higher degree of confidence, but
Right.
it's going to be a while before it starts doing that. But again, I think like dealing with the privacy aspect is going to be huge for these companies if they want widespread adoption in the legal field,
Mhm.
because the practitioners and the clients have to be very, very confident that, if someone were to try to move to compel saying you've blown up the privilege, you'd say, no, I haven't. Right.
Yeah.
They have to be confident of that. So they're going to need legislation or they're going to need terms of service that make it clear that, if it's a legal product, they're just going to I mean, my guess is they're just going to make a bunch of off the shelf legal products and they're going to design them with preserving confidences and preserving privacy to the maximum possible extent. They're going to design them with that in mind.
Right. I mean, like Lexus and Westlaw just
Yeah.
take their existing and, here's this is for lawyers and, for extra
Hmm.
$50 a month, we could give you an AI just evaluation. So, yeah.
Yeah, exactly. That's what's going to happen. And those companies are really well positioned for that because honestly, with all these new players popping up all the time, I honestly think that the AI LLMs are going to become commoditized, right? And the
Yeah.
real hard part is going to be what Lexus and Westlaw have already mastered.
Yeah. And I mean, you see it in pretty much everything in computers, right? They had
Hmm.
a whole surge of production, everybody making a new hard drives or a new, it's the
Hmm.
external CD players. And then, you know, 18 out of 20 went out of business within a year.
Hmm.
So yeah, it'll be the same thing.
Hmm.
Well, good. So it took you for, I guess, a little more than an hour here.
Hmm.
Any parting thoughts or any observations, predictions of the law? Is it going to continue as it is, or good changes, bad changes?
I think that it's hard to predict, I mean, but I think that AI is going to change things, but generally speaking, like there's kind of a straight line from sort of the Magna Carta until now, where you've had more or less kind of similarity in the practice of law, where you have like a courtroom and a bench and a
Right.
bar and
Mhm.
all, I mean, you have the Inns of Court in England and stuff. And so I really think the law is a really slow moving profession. And it's going to change, but it's not going to be a revolution. It's going to be on the margins, you know?
I mean, look at where we're at now with worldwide plague, and
Hmm.
everybody's doing, meetings like this. Um,
Yeah.
so is that what it's going to take? Another crisis, or it'll go along steady Eddie and then jump to the next level, or
Yeah. I mean, it's hard to say, right? It's hard to know. I mean, I, I think like the ways people gather information and communicate information will change, but the presentation of that information in a courtroom before a jury and a
Mhm.
judge is not going to change a whole lot, is my guess.
Right.
The back end of it, like how you build your case, how you gather information, that will become hopefully more efficient all the time. And the more you can push that away from a billable model and you have a machine doing it, the the cheaper litigation becomes, and hopefully there's more disputes where people can actually hire a lawyer.
Right.
So it's not a bad thing, you know, price will go down if you automate certain things. But I just think the way we've practiced in the English common law system has been around for almost, you know, it's like a long time,
Yeah,
800
right.
years, something like that. And I just think that that's probably set to continue more or less the same with changes on the back end about how you gather information and how you deliver a written work product to your client and stuff
Right.
like that. But what's going to happen, of course, also is that general counsels at big companies are going to demand it. They're going to say, you have to use this product. I mean,
Right.
already when I was at Jones Day, we would have some big clients who would say, look, we have our own contractual relationship with this e-discovery vendor. You
Mhm.
must use them, right? Like you have
Oh,
to use
okay. Well,
this e-discovery vendor because we have a huge amount of litigation and we use them and we have a rate structure to negotiate with them. So, and so you did. And so you're going to have similar stuff where I think they're going to say, you know, you must use certain tools if we retain you. But yeah, and like in a practice where you're representing a lot of individuals, you know, it's going to be up to you. It's going to
mhm.
be the marketplace kind of decides based on who's able to best deliver performance at a good price.
I know in Fairfax, I'm watching in the bankruptcy court, I was there when they went from paper filing to electronic filing.
Hmm.
Now Fairfax and some of the others gone into electronic filing, electronic service. So you can send over, all your documents, production that way. And I
Hmm.
was at a meeting the other day on Zoom, Fairfax Circuit Court, and one of the judges was asking for the beginnings of a proposal on
Hmm.
electronic presentation of evidence. That
Hmm.
apparently they had one file with 50 exhibit books,
Hmm.
and everybody was passing them around and flipping them open. And what about what's in this book on page
Hmm.
17 and this book, on page 84? So he was suggesting, I guess, with the permission of the bench, was if it's more than an inch thick, think about electronic presentation. So we'll see.
Hmm.
That could be a revolution all by itself.
No, that's true. I mean, I prefer electron. I grew up in an era where it's like we were using Pacer and stuff right when I got out of law school. And
Mhm.
so you're submitting everything in federal court electronically. We had some stuff in state court we had to do manually on paper. But yeah, I wish they would modernize Pacer so that you can submit files bigger than 30 megabytes or whatever. And I'm a big believer that Pacer should be free to non-lawyers. I mean,
Yeah.
Pacer should be free to people who are okay, if you want to charge lawyers a filing fee or whatever, that's fine. But the general public should be allowed to access Pacer for free, I think.
Yeah, yeah, I agree. Oh, anyway, I don't know what the inside workings of Pacer are, but I'm not happy with them, but they are what they are. So,
Yeah, absolutely.
well, good. Well, I appreciate your time and good luck on the soccer game there. So,
Thanks. Yeah, I'll
all
go
right.
see what the score is. But yeah, thanks for having me. It was a pleasure
Mhm.
meeting you, Randall. And
Very good.
yeah, I look forward to seeing us posted somewhere.
See you around.